Hi, I'm Elisabeth Camaur from Camaur Crampton Family Law. I am a certified family law specialist by the State Bar of California's Board of Legal Specialization. I've been working in the area of family law in California since 1993. My office works in the areas of divorce, child custody, restraining orders, registered domestic partnerships, and other family law matters. Now, if you know somebody who's going through a divorce in California, you may have heard them refer to their declarations of disclosure. This is an essential part of a divorce case. In California, the law has imposed a duty of the parties, a fiduciary duty, a duty of the highest trust concerning the community finances. This is a duty similar to what an accountant would have to his client. It's a duty of disclosure of income, expenses, assets, and debts, and it is a duty to manage the community estate, the community assets, the community finances in an appropriate manner. When parties are going through a divorce proceeding, by statute, by law, the court is not allowed to enter a divorce unless the parties have completed declarations of disclosure. Now, what that is completing judicial counsel forms, which include the income and expense declaration, the schedule of assets and debts, the declaration of disclosure page with all requested information and statements attached. Then they also will need to file and serve this declaration of disclosure form, which is called a declaration regarding service of declaration of disclosure. This form tells the court that the side has already exchanged and provided their declaration of disclosure information. Now, by law, you cannot divide assets and debts, you cannot enter into an agreement concerning assets and debts, and you cannot get a final judgment of spousal support without completing the declaration of disclosure. Moreover, if there is no omitted asset, if there's an asset that's been left out of the judgment or left out of the disclosures, the court does have the power to divide that asset later. However, there is a line of case law that says if there's an intentional omission or an intentional misrepresentation of an asset, the court does have the power to allocate that asset in its entirety to the other side. People need to be very careful and very thorough when doing their declarations of disclosure in divorce cases. Now, what happens if they don't do their declarations of disclosure, but they get a divorce anyway? It slips by the court. There's a provision in the law which allows a court to vacate a judgment for divorce, division of property, and or spousal support. That means if later it's found out the parties actually did not do their declarations of disclosure, the court can then undo the divorce. If you are going through a divorce or you know somebody who's going through a divorce, make sure you do your declarations of disclosure properly the first time. Make sure that you're going to avoid future litigation and that there will not be problems later. Please discuss these issues with a qualified family law attorney so that you can get the proper advice to make sure you do your divorce the right way the first